This is FBT TV. Last week I have prepared a video which is very short actually, and I've been announcing everyone to watch over the video in correlation with the I do have some short explanation on judgment of contradiction, and it has been presented with this audio, and watch it as follows. Last week I have prepared a video which is very short actually, and I've been announcing anyone to watch over the video in correlation with the I do have some short explanation on judgment of contradiction, and it has been presented with this audio, and watch it as follows. In an ancient time, during an emperor Haile Selassie era, there is the law which have broad selected for church law and civil law, and that was the base for judgment of introduction, which has been transferred to civil code of Georgia. It is still functional. So these articles, which have been depicted in an ancient decree of Emperor Haile Selassie, do have its own principle, procedure, and protection of judgment of introduction. So you can watch over the audio which I've presented it as follows. Now let us hear what Ethiopian Civil Code says about judgment interdiction.
Of Haile Selassie, the Fetha Nagast served fundamentally as a book of both ecclesiastical church law and judicial civil law. Within the Fetha Nagast, there are provisions concerning civil disabilities, legal incapacities, disqualifications. The main regular restrictions imposed on a person who is legally disqualified, for example, due to renouncing the faith, conviction of a serious crime, or mental incapacity include: they cannot serve as a witness in court. They are not permitted to buy or sell property by their own authority. A guardian or legally responsible person is appointed. They are barred from Christian social, religious rites, such as giving testimony or leading religious rites. In some cases, they may be separated from the community, excommunication or exclusion. Specifically, in the book these restrictions are listed under the headings: those who may not testify, and those lacking legal capacity. picked up from Ethiopia Civil Code, number 342 to 360. Chapter 3. Insane Persons and Infirm Persons. 1. An insane person who is an inmate of an institution. A person shall be deemed by law to be notoriously insane where by reason of his mental condition, he is an inmate of a hospital or of an institution for insane persons or of a nursing home, for the time for which he remains an inmate. Art. 343. Juridical acts of notoriously insane person. 1. Principle. Juridical acts performed by a person at the time and in a place ID which his state of insanity was notorious, may be impugned by that person, by his representatives or by his heirs. 2. The same shall apply to juridical acts performed by a person where the infirmity renders such person unfit to take care of himself. Section 2. Judicial Interdiction. Art. 35L. 1. Judgment of interdiction. The court may pronounce the interdiction of an insane person where his health and his interests so require. 2. The interdiction may also be pronounced in the interest of the presumptive heirs of the insane person. 3. It may also be pronounced in the case of a person who is unable through permanent disability to govern himself or to administer his estate. Art. 353. Application for interdiction. 1. An application for interdiction may be made by the insane or infirm person himself, or by his spouse, or by any of his relatives by consanguinity or affinity, or by the public prosecutor. 2. The judgment of interdiction may be given before the person whose interdiction is applied for attains his majority. 3. It may not be given after the death of the person whose interdiction is applied for. Procedure for interdiction. 1. Before pronouncing the interdiction of a person, the court shall be convinced that such measure is necessary. 2. It may not pronounce the interdiction without having seen the person whose interdiction is applied for. 3. Where the personal appearance of such person is not possible, the court shall proceed to his examination either by delegating one of its members or by appointing an expert. 355. Appeal. The insane or infirm person himself, his spouse, any of his relatives by consanguinity or affinity, or the public prosecutor may enter an appeal against a judgment of interdiction. Art. 356. Register of judicially interdicted person. 1. A special register kept in the registry of each Teklageza court shall contain the list of every person whose interdiction has been judicially declared, residing within the jurisdiction of the court. 2. The register shall contain only such details as are necessary to identify such persons and to identify the judgment or judgments relating to the interdiction. 3. It may be perused by any interested person. Art. 357. Notice of judgment. 2. The guardian of the interdicted person shall ensure that the judgment of interdiction be brought to the notice of the registry of the court of the province or provinces where the interdicted person resides or is called upon to reside. 2. The same shall apply to any judgment modifying the effects of the interdiction. Art. 358. Protection of interdicted person. Without prejudice to the provisions of the following articles, a person who has been judicially interdicted shall be subject in respect of his person and of his property to the same rules of protection of a minor. Art. 359. Guardian and tutor. The guardian and tutor of an interdicted person shall in all cases be appointed by the court. 2. No person, other than the spouse, the ascendants, and descendants of the interdicted person, shall be bound to retain the functions of guardian or tutor of an interdicted person for more than 5 years.
In relation to this judgment of introduction, on application of judgment of introduction, I have never have applied, but one my parents have applied. 2 prosecutors, that means the government state, and the next, which have been mentioned under Article 300. On the other hand, it also inside under this article 353 that and the majority rule, so it might be concerning all the societies, including the religious societies too. On the other hand, on Article 354, it entices about the judgment of introduction in relation to court. So the judge must outweigh the necessity of passing such introduction. Second, the judge must pass such judgment of introduction in the presence of the man to be interdicted appearing at court. If no appearing has been at court, he might establish an expert to investigate the detail of introduction of a man. So all have been done seriously against me and breaking this Article 354. 355, Article 355, here it says on appeal. On the case of appeal, no one have appealed for me. If they had made it, I never have been under such introduction till today. So I have made an accusation at Oromia Supreme Court, and this was taken to the Justice Minister, different democratic institution in Ethiopia, and currently it is at Prime Minister office. On the other hand, in relation to protection, I will explain it like this. The protection under Article 358 explains that the right of judgment of introduction have minimum the right of minor. That means minor have been defined in this relation such a way that someone have been in a state of being childish, needing a support, or legally under such impact of being put of such right. So have been correlated with a rise of minor. This is inhumanity and then is probably human rights alienation committed to be from the family members, societies, religious societies, and the government itself, breaking an international humanitarian law and breaking charters of African Ethiopian descendants and human rights declaration declared under United Nations. I'm Dr. Gasala. Thank you for watching the video and condemn such deed of Ethiopian government.